For decades, millions of workers were forced into secret arbitration when they experienced sexual harassment. For decades, millions of workers were forced into secret arbitration when they experienced sexual harassment or assault at work.
I hired you because you're a beauty queen.
That meant silence. No judge, no jury, no public record.
I built Tinder with them. If they can just delete me, it's like they've done nothing wrong.
You say anything, they can sue.
But in 2022, that changed. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act gave survivors a choice. They could take their cases out of secrecy and into public court. Now, for the first time, we know what that change looks like in practice. A new analysis by Lift Our Voices and Professor David Horton at UC Davis reviewed every accessible court decision involving the EFAA since it became law. The findings are clear. Survivors are using this law. Courts are applying it as Congress intended. And cases that once would have disappeared behind closed doors are moving forward in the open.
For us to be able to finally tell the truth and say what happened. It was terrifying and it was hard and it hurt, but it was the most important thing I've ever done.
This is what access to justice looks like. Lift Our Voices fought to pass this law. Now we are showing how it works. And welcome, everyone. I'm Gretchen Carlson, a co-founder of Lift Our Voices, along with Julie Roginsky, who's also a co-founder today. We're so happy that you would join us on this 4-year anniversary already. Julie, it's hard to believe. 4-year anniversaries of one of the biggest labor law changes in the last 100 years, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. We fight against silencing mechanisms at Lift Our Voices. We're the only organization that does that as a nonprofit in the United States. We fight against forced arbitration and non-disclosure agreements. And let's show you some of the scary statistics about why our work is so necessary. So this year alone, 84% of all workers will be under forced arbitration, more than 60 million Americans. 1/3 of all workers sign stringent NDAs on their first day of work, thinking it's only to protect trade secrets, but most of them are much more expansive. This has exploded over the last 40 years. Just for purposes of how that has happened, in 1991, only 2% of all American workers were under forced arbitration. So the silencing inside of our companies where we work has just exploded. Julie?
Well, the sad part of this, Gretchen, is that the more disenfranchised you are in society, the more disenfranchised you are at work as well. What we know is that these silencing mechanisms, especially forced arbitration, impact all workers. But look at these statistics. If you make $13 or less an hour, minimum wage, or just slightly higher in some states, certainly just a little bit more than the federal minimum wage, 65% of those workers are bound by forced arbitration. That means that if you are racially discriminated against at work, or for any other reason, effectively, you have no recourse. You have to go into the secret chamber of arbitration, where you're not going to get paid your fair share, where you're not going to be able to have access to any kind of real justice. And companies know this, and they know that the more they disenfranchise you at work, the more it's possible that you will not be able to receive any kind of justice in a court of law. That's what we're fighting against.
And that's why passing laws is so important, to try and change this system. And Lift Our Voices, as we said in the video, partnered with Professor David Horton, who is an expert on forced arbitration, to study the impact of the law. And he is one of our guests today, and we're so glad to have him with us. David Horton is a Fair Business Practices and Investor Advocacy Endowed Chair and a Martin Luther King Jr. Professor at UC Davis School of Law. And Julie, you're going to introduce our other guest.
Yes, I'm so happy to have Holly Carone joining us as well. Holly's an attorney at Meyer Employment Law in Portland, Oregon. And Holly represents employees in wrongful termination and workplace civil rights cases across the board. So we're both so glad to have you here today with us. Thank you so much for joining us.
So we're going to kick off with David because you did the study, David, and we want you to give a brief overview from what the study actually found. So take it away.
Great. Well, thank you so much for having me. So I took a look at how courts have been interpreting the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act since it was passed 4 years ago. And essentially, I looked at all accessible cases that I could find that came out between when the statute became law and the end of August 2025. And before I get into it, I just want to point out something that might not be obvious if you're not familiar with arbitration law. Something that I think really underscores what incredible work Lift Our Voices did with this law. So people have been trying to pass statutes that narrow the scope of the Federal Arbitration Act for decades, and it was widely believed not to be possible. So it's really a testament to the work that Gretchen and Julie and all other people associated with the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act were able to do, that they did get this law passed. Emily, could you please go to the next slide? So there were about 230 reported cases in which a court grappled with the issue of whether, and I'm just going to call it the EFAA, applied to exempt a plaintiff from having to arbitrate their case. So the issue was whether or not they could actually go to public court or whether they had to go to private arbitration. And about 123 times, courts concluded that the EFAA applied, and therefore they allowed a plaintiff to remain in the court system, which is a tremendous victory for these survivors of sexual assault and sexual harassment. When you look at the way these cases break down, you can see that generally they cluster in populous states like California, like Texas, like New York. I mean, this is what you'd expect. There just simply are more legal claims arising out of these states, but also something that I didn't expect to find, but definitely shows up in the data, states that tend to have sort of more liberal sexual harassment laws tended to have more claims under the EFAA because it's easier for a plaintiff to show that they have actually suffered some kind of sexual harassment or discrimination. Next slide, please. The primary reason the EFAA did not apply is the fact that Congress specified that it wouldn't apply to acts that occurred before the statute became law. So if a plaintiff suffered sexual assault or sexual harassment before the date the EFAA became effective, a court had no choice but to enforce any arbitration agreement that that plaintiff was subject to. So as you can see, when you take a look at this chart, if you look at the sort of red bar, those are all claims that may have been viable sexual assault or sexual harassment claims, but nevertheless had to go to arbitration because they accrued or the dispute arose before the statute came into effect. Now, this issue is going to disappear because as time passes, there will be fewer and fewer plaintiffs seeking relief for action that happened before March 2022. Next slide, please. One of the best parts about the EFAA from a survivor's perspective is the fact that Congress was clear in the text of the statute that if you can allege a plausible or viable sexual assault or sexual harassment claim, it's not just that claim that remains in the court system, it's the entire case. And so what this means is if you break down the types of claims that have been able to remain in the court system because of the EFAA, it actually goes well beyond sexual assault or sexual harassment. So the most common type of claim that was exempted in my data was sexual harassment under state law, because actually many states do have law that is more pro-survivor than federal law, which has some strict requirements. But other than that, you can see that other common types of claims that were exempted from forced arbitration include wrongful firing and tort claims, in addition to other types of discrimination, like racial discrimination. And one of the reasons this is especially important for survivors is that it's very difficult and expensive to have to pursue part of your case in the court system and part of your case in private arbitration. Not only that, but if you've been the victim of really unpleasant conduct, you have to relive those experiences in two separate legal proceedings. So far and away, one of the most valuable aspects of this statute is the fact that it enables survivors to bring their entire case in the court system, including claims that aren't strictly sexual assault or sexual harassment claims.
That's so helpful, David. Thank you so much.
Really helpful, David. Thank you. Holly, I want to ask you, because in the real world where you practice, you represent survivors. And so from the courtroom perspective, what did the EFAA immediately change for your clients?
It's been very helpful. I would say probably right now with my current docket, I would say, I mean, this is an estimate, but about 25% of all of my cases that I currently have, I have used the EFAA to get them out of arbitration. So it's something that I regularly use. And it also really, I mean, on top of just, not being forced into this secretive process, it also, at least in Multnomah County, which is where most of my cases are brought, really helps just actually increase the value of their case, which, especially if you have any sexual harassment or sexual assault, but especially for my clients that have been sexually assaulted, it can be feel a little odd, obviously, putting a price tag on, this traumatic experience. And so having a higher price tag, I guess, for lack of better words, it makes them feel heard and like they didn't experience this traumatic event, and they're not going to be treated like it's nuisance value, which we have heard many times before, unfortunately. So on top of one, again, just feeling like their voices are being heard, and then also feeling like there's going to be some kind of possibility for resolution that is more adequate to, again, the experience that they had, has been very helpful for them.
Let me follow up on that, because I think Gretchen and I can speak to this ourselves from what we went through after our respective experiences at Fox. Before this law went into effect, you really had people being shocked when they walked in to see a lawyer like you and being told that, no, actually you can't sue. It doesn't matter how much evidence you might have accrued. It doesn't matter how strongly you might feel about something being done to you. It doesn't matter if you, in some ways, were assaulted with evidence. You could not sue if you had an arbitration clause. What is that, as an attorney, bring us into that discussion now, where women are told that they have a choice in a way that they didn't have before?
I think that the best example is actually the case that kind of brought me into contact with you guys, because that one was a little less obvious. I mean, some of my clients, they have a straightforward sexual harassment claim. And so for them, frankly, there actually isn't even a ton of conversation, because it's like so automatic now that I'm like, oh, this is not, like, the arbitration agreement is not going to be enforced. In fact, most of the time, and this is something that David had mentioned in his paper, like, these aren't even, we'll file a lawsuit and they're not even filing a motion to compel arbitration, because it's just not even, worth the defense attorney's time, frankly. But for cases that are a little bit more, maybe the legal argument is like a little bit more nuanced, like Nicole Pollan's case, where, she, in Oregon anyways, there's state laws that protect victims of domestic violence and sexual assault, and different sex crimes and whatnot. And if they need safety accommodations, their employers are legally required to provide them with those safety accommodations. So for, Nicole, it was a little less obvious whether or not that was going to, the EFAA was going to provide her protection to get her out of her arbitration agreement. But just, I think the thought of, she's a little fighter, honestly. So I think just like the thought of having an argument that we could make, and just being able to, it's just frankly, I think another way of her being able to stand up for herself. And I mean, it's exciting for me because I'm very passionate about this and I love making legal arguments, but it's also exciting for her because, again, it just makes her feel empowered that, her and I talked about this extensively and, talked about the pros and cons and the risks of obviously the court not ruling in our favor and whatnot. And so I think that it's just like when you're going to trial, I think that, people want to be heard, and just even this first little layer with the judge of hearing her argument and having it validated has just been really nice for her. So yeah, it's like I said, that's probably a better example where it just feels good to, like, when you've experienced something, again, so traumatic, to just have a little win under your belt feels good. So
Yeah, I get it, Holly, because one of the biggest things, hard to believe, almost 10 years ago now, when I came forward at Fox News, the darkest day for me was when I assembled the legal team together and they looked at my contract and they said, "We got some bad news for you." And I was like, "What?" And they're like, "You have an arbitration clause. You can't sue." And I was like, "What are you talking about?" So this is something that people don't understand, even highly educated people, not educated people, CEOs, minimum wage workers. It affects millions of people, and most people don't understand what it means with regard to their rights. So, David, now that we're opening up Pandora's box and giving these rights back to employees, I imagine there's been pushback from employers. In fact, I know that to be true. So what do you think are the most common strategies that you're seeing to try to limit this new law's reach?
That's a great question. So there have been two main strategies that I've detected. One of them is to argue that whatever the plaintiff is complaining about isn't, quote, sexual assault or, quote, sexual harassment. And so there, the terms sexual assault and sexual harassment are defined within the statute, but they're defined in a way that's fairly broad. And so there's been legal battles over what the proper contours of those phrases are. So employers are often arguing that the type of conduct that an employee is complaining about doesn't even fall within the statute itself. The other issue relates to whether or not a plaintiff has to plead facts that state a plausible claim of sexual assault or sexual harassment. So without getting too deep into the weeds, if you're in federal court, there's this baseline requirement that your complaint, which is like your version of what happened, needs to be plausible on its face. It needs to sort of tell a story that, if true, would entitle you to relief under the law. And so what employers have figured out is, because it actually can be very difficult, especially under federal law, to state a claim for a violation of Title VII, which is the big federal anti-sexual harassment statute, that there's room to dig in and argue that even if some bad things did happen to this worker, it doesn't amount to a legal violation. So those are the big battlegrounds so far.
Well, and I'll just add in, because we talked to tons of people who still reach out to us, the employers are also trying to tell the employee that they have to abide by arbitration, hoping that they don't hire a lawyer and they don't figure it out on their own, because the statute does not require that the employer put it in any new contracts moving forward, even that this group of people, sexual assault and sexual harassment, are exempt from forced arbitration. Because why would they do that? Because then if you're racially discriminated against, they'd have to write in your contract, hey, if you're sexually harassed or assaulted, you don't have to go to the secret chamber of arbitration. But if any bad other thing happens to you, like gender discrimination, age, disability, race, you do. And so the onus is on the employee to understand this law. I want to ask you just a quick follow-up, David. Are courts buying these arguments that employers are trying to put forth?
So generally, no. The thing that really kind of shines through when you take a look at all the cases is that even though there's some disagreement among courts, they are interpreting the phrases sexual assault and sexual harassment quite broadly. And although courts are really split over exactly what a plaintiff needs to put in their complaint in order to invoke the EFAA, Many of them have decided that the standard is actually quite easy to meet, that all you need to do is allege a non-frivolous claim in order to invoke the statute, which means then you don't have to arbitrate and you can remain in the court system.
But there is something here that does matter, Holly, and that's timing, right? Timing for these cases. So why does the timing of when a dispute, quote unquote, arises, why does that matter so much under the statute?
Are you talking about just like the applicability of it?
Yeah.
So any dispute that, well, there's some wiggle room here. I mean, this is a new law, obviously, but typically if the sexual harassment or sexual assault dispute took place before, David, is it June 2022 or was it April 2022?
March.
I think it's March, yeah.
Oh, was it? Okay, so none of those. But first time in 2022, so March 2022, there we go. Then the EFAA would not apply. But I mean, I've also just kind of thought about it. I mean, if the sexual harassment or something like that started prior to that, but then it continues after March 2022, then that would still apply. So,
yeah, and I think that's an important point to make, right? Because I think the way this is written, it means that if something happened to you before March of 2022, then you're out of luck. But the reality is, we know that practically speaking, harassment or assault, but really harassment, doesn't just stop magically, right? And if it continues on and on and on, even if it's been going on for 20 years, I mean, we know stories about people who've been harassing their employees going back decades. I mean, prior to maybe some of us on this call being born. And so if that continues to happen, and it happens well after this or even a day after the statute went into effect, which is 4 years ago tomorrow, right? The applicability of it extends beyond anything that was going on before that, even if it began before.
So, yeah, go ahead, Julie.
Yeah, I mean, so just to clarify, Holly, because I think for people who are watching this, it's not when the survivor brings the complaint, right? It's when, or even when the arbitration clause agreement was signed. It's just when the harassment or assault happened or continued to happen.
Exactly. So even if, I mean, arguably, even if the bulk of the sexual harassment happened before March 2022, if you just have I guess it probably, I'm sure obviously there's a lot of variation, but even if, just a portion, a small percent of the harassment happened after March 2022, you have a very good argument to the EFAA would apply. So yes.
Yeah, I think there's a federal case that there's a ruling on that, right, David? I mean, there's a federal case that said I think she was already maybe potentially in arbitration before March 3rd, 2022, but she stayed in the job and the harassment continued after the law passed, and the judge or the combination of them said the law still applies, she can come out of arbitration. So there have been some really great, more broad rulings for survivors. David, I want to get into the outside of the office activity with regard to assaults or harassment, because many times this kind of activity happens not in the office space, but on a business trip or at a restaurant or something like that. So the EFAA, this law protects survivors even when the assault occurs outside or the harassment occurs outside of the workplace. I know for us, this was really important for this to be included in the law. What's your interpretation of that and how important it is?
Yeah, that's absolutely right. This is a huge and important part of the statute. So the statute actually applies and therefore invalidates an arbitration agreement in any case that relates to any dispute about sexual assault or sexual harassment. So when you really drill down and you look at each of those words, which is what courts have generally done, you see that all a plaintiff needs to do is to say that they have some dispute that is related in some way to an act of sexual assault or sexual harassment. That means it does not have to happen at their workplace, just like you said. It also means that it doesn't have to be the bulk of their claim. There can just be one incident that involves sexual assault or sexual harassment, and the rest of their case is relatively connected to that. But if the case itself has some kind of relationship to this single claim, then it will be exempt. I also just wanted to briefly mention one quick thing about timing. Everything that you guys were talking about with respect to continuing sexual harassment is exactly right. And I just wanted to quickly say there's also one other avenue for survivors, which is if you have been sexually assaulted or sexually harassed and you haven't complained about it yet, then you don't have a, quote, dispute within the meaning of this statute. And if you do complain about it now, that is when your, quote, dispute arises, which means that your dispute will be timely and you can invoke the statute. So there's two timing mechanisms. One looks at when the wrongdoing occurred, but the other looks at simply when there was some disagreement about conduct. And even if the disagreement occurs years after the conduct, as long as it's after March 2022, the claim is timely. So I just wanted to point that out.
Yeah, no, that's so important. I'm sure employers have tried to argue against all of these situations that you're bringing up because, the first order of business is to try and find a loophole in a law, right? But I want to go to LinkedIn because we have some questions and this is really important because we're trying to educate other lawyers as well. I can't tell you how many times we talk to survivors and their own lawyers don't understand the statute yet or don't know about the statute. So the question from LinkedIn is, for lawyers watching, what's the biggest mistake attorneys are making when trying to invoke the EFAA? David, and then Holly, if you have an answer.
Right, that's a great question. So the thing that I've seen, at least in the reported cases, is that some lawyers unfortunately don't understand that they can exempt the entire case, even claims that aren't sexual assault or sexual harassment.
Holly?
Can you expand? Can you just expand on that before we go on? Because I think that's a really critical point there, David. Just tell us what you mean by that, what your research showed, because I think it's a monumental aspect of this law that people don't realize.
Yeah, sure, absolutely. So as employment lawyers know, very often an employee will have multiple claims because they've been the victim not just of sexual assault or sexual harassment, but also they've been wrongly fired, or their employer withheld their wages or didn't pay them overtime. And so there are all kinds of claims that typically arise in an employment lawsuit. It just takes one viable allegation of sexual assault or sexual harassment for all of those claims to proceed in the court system, because the language of the statute is the whole case is exempt.
It's amazing. I mean, it really is amazing for survivors. Another example would be if you're an African-American woman who's being racially discriminated against and sexually harassed. Instead of bifurcating that into two separate courts, that's what you're saying, is that judges are ruling that the whole thing can stay out of arbitration, which is a huge victory for people's rights at work. Julie, I have another LinkedIn question, but go ahead with Holly.
Yes, well, I want to make one more point before we do that, just to what you said, Gretchen. If you look at EOC complaints, right, the people who complain the most about being sexually harassed at work are actually African-American women. Because as you pointed out, Gretchen, it's not just that you're sexually harassed. It is that very often it is also couched very much in racially discriminatory language. And so what this allows you to do is not live in a separate but equal frame, which right now we have in the workplace, which is that if you've been sexually harassed at work, you can go ahead and have your day in court. But if you've been racially discriminated against at work, you're out of luck. You still have to go to arbitration. We're working on that here at Lift Our Voices to change that. But the reality is, until we do, I think people watching, both lawyers and also survivors, need to understand that you have rights that are not based, from your research, David, that are not just based on whether you've been harassed or assaulted. It's also based on the fact that if that harassment and assault was couched in racial language or any other kind of language, disability or age, or as Gretchen said, wage theft or anything else, you have rights that you might not think you have because you don't think that the EFAA applies to you. It does. It does, from what you read. So I think that's really important for people to be aware of right now. We talked about, Holly, without revealing confidential details. Can you walk us through how the EFAA changed the trajectory of one of your cases? I know you talked about Nicole, but is there something else that you can talk about? Anything else along those lines?
Yeah, I mean, another vague example that I have is, I have a case right now where I think that, I mean, it's not just women. I think anybody that experiences discrimination, sometimes just depending on the person, it can be, I think certain kinds of discrimination can carry a little bit more shame than others. Or it could also just be a, subjective or objective thing. But I have a case right now where sexual harassment actually was a pretty big part of my client's experience, but on top of that, she also experienced disability discrimination. And that was initially the reason why she had come to us for help. And only after, talking to her and getting to know her and just really getting to know her story did I realize that, the disability discrimination was truly horrific, but she also experienced some pretty, not minimal sexual harassment that I just think that, frankly, she was just a little bit more uncomfortable talking about. But I explained to her, I was like, we can pursue this however you want. You have an arbitration agreement, but, as I mentioned before, I let her know, I was like, if we can get out of arbitration, arbitrators, they're much less likely than a jury to give like this nuclear verdict we call, where you get this huge settlement. And so it, unfortunately, like I said, negatively affects the value of the case, because there's just, that looming risk to the employer that they might get some $1 million jury verdict is not, hanging over their head, basically. And so I explained to her, I was like, if you're willing to bring these claims as well and talk about them and whatnot, then we can get out of this arbitration agreement and, bring this case in Multnomah County that is very plaintiff friendly, and has been known to give some really crazy verdicts out here, so which is good for me and my clients, obviously. But I mean, that has been, again, I'm a plaintiff's attorney that works on a contingency fee, and I really just need to like the case in order to take it. But there's a lot of attorneys that if they don't think the case is valuable and they're working on a contingency fee, they're not even going to take it, and so it makes it really difficult for a lot of these plaintiffs to even find an attorney to begin with. And so if they have an arbitration agreement that is going to make it just, it's just the unfortunate truth, just make it attorney feel like it's not worth putting the time and effort into, that is really tough, especially when you are a person that has just experienced some really awful treatment, just kind of come face to face with the fact that, the justice system also has businesses that need to function, and that can really affect your ability to find representation.
Yeah, I want to actually throw some stats in there about what you said, Holly, because they're pretty startling. So of all cases that can go to arbitration, only 2% do, and you might wonder why. The reason for that is because of that 2%, only 2.5% result in any kind of financial compensation for the claimant. And so when you think about it from that perspective, if you have an arbitration clause, and again, to go back to the statistics we talked about earlier, it is more women than men. It is typically more Black women than anybody else. And it is overwhelmingly people making 65% of whom make $13 or less an hour. What you're talking about is that you shouldn't even, a lot of people might feel like they shouldn't even bother, because the odds of seeing any kind of justice are next to nothing. And I guess we're here to say to you, 4 years in, that that's not true when it comes to sexual harassment and assault. We're able to solve for that problem right off the bat. But it's also beyond that, as to what we talked about earlier, which is that you might have a case, even if you don't think you do, based on how expansively some of these laws have been interpreted, or some of these trial courts have been interpreting this law based on your research, David. So from that perspective, yes, I can tell you, when I went to go sue Fox, the first question my lawyers asked me is whether I had an arbitration clause. And if I had an arbitration clause, which I did not, they would not have taken the case. Not because they didn't think I had one, but because they knew the odds of succeeding were so minuscule. Mm-hmm. That is changing. And this law is changing it, and not just for sexual harassment and assault, but again, as we talked about earlier, for different issues, as long as they're wrapped into some sort of sexual harassment or assault component. So I think that's really important for people to know.
Another question from LinkedIn for you, David, and I love this question because this is what Lift Our Voices continues to work on. Our work's not done just because we passed the EFAA and something called the Speak Out Act, which we'll get to in a second with regard to NDAs. But the question, David, is if Congress expanded this law tomorrow beyond sexual misconduct, what would be the strongest legal argument for doing so?
Right. That's a great question, too. So in terms of, whether Congress is going to expand this statute beyond cases of sexual assault or sexual harassment, one of the things that we just have to be very clear-eyed about is that there is really strong opposition to any new congressional law that would narrow the scope of forced arbitration, because there are really, really powerful lobbyists that will vehemently oppose anything that stops companies from using forced arbitration. So I think a lot of activists who are trying to limit forced arbitration are focusing on other sympathetic subgroups. For example, there was a bill that was introduced last Congress that I believe has been reintroduced that would exempt older Americans who have experienced age discrimination from forced arbitration. And, just being pragmatic about it, the reason why advocates are focusing on these groups and not trying to necessarily pass very broad laws is that there's a long track record of very broad laws that would repeal the Federal Arbitration Act failing. So advocates are really focusing on looking at plaintiffs who are very sympathetic. For example, someone who has suffered age discrimination will have experienced, conduct that is not just unpleasant, but also extremely common. And age discrimination cases have, some really important components in them. They belong in the court system and not in private arbitration. So I think most likely, if there are going to be other successes, they're going to be incremental.
Totally. You're speaking about us behind our backs. Actually, we're right here, David, because it's us with the AARP who introduced the Protecting Older Americans Act. You and I actually testified together last September before the Senate Aging Committee on this. And to your point, yes, our strategy has been to incrementally add in other protected classes. To your point, something called the FAIR Act, which would have gotten rid of arbitration for all worker issues as well as consumer arbitration, it's just not going to pass because you have to have it bipartisan, at least in the Senate. And it's just not going to pass with this current Congress. So yes, the strategy has been to do it incrementally, which is why we've been so excited by your research to show that many of these cases are being interpreted more broadly to include other protected classes and not just sexual assault and harassment. Julie?
So, Holly, I want to ask you, for people from a practical perspective, if they want to go and speak to a lawyer and use this, what should they do? Prior to seeing a lawyer, what kind of evidence should they gather? What kind of language do they need to use with HR, if any? Should they go talk to HR before seeing a lawyer? What should they do in order to make sure the EFAA is most effectively used for them?
I would definitely say try to document. That is probably the biggest thing that will help you find a lawyer. It is very difficult when it's just kind of a he said, she said, or he said, or, situation. Even just sending an email to someone, I used to be a server, so I understand that sometimes you're in these jobs where emailing each other, email is just not a common form of communication, but even sending a text, if you're having a verbal conversation with a manager or supervisor about sexual harassment, just sending a follow-up text or a follow-up email, even though it just doesn't, depending on the profession you're in, might seem a little out of character, offering yourself that little extra evidence, frankly, can be very helpful in finding an attorney. And also just, this is tough, but I always kind of I do a lot of the client intake here. And so I like talking to people. I like interviewing potential clients. So if, we're a small firm, so we can only take so many cases. But if I am talking to somebody that I think potentially has a case, but we just don't have the capacity to take it on. I tell them also, I'm like, when you're talking to lawyers, maybe drafting a timeline and just sticking to staying focused, staying focused on the issue that is bringing you to the attorney's office, which is either, sexual harassment, sexual assault, and that and documentation would probably be the big things. And like I said, it could be email, it could be a text message. If, a lot of these people are getting inappropriate messages, so making sure that you save those messages. Even frankly, I have people that have just kind of taken notes, in the little notes app of their phone that has a timestamp of the day that it happened, just anything like that, to protect yourself. Because like I said, when it's just these verbal communications, it's certainly, if you have witnesses and whatnot, you can still make a case out of it, but it is much more difficult. And just honestly flagging it for people. I was flagging it for potential attorneys that this is an option, because I was actually just talking to my boss about this. He's like, I've actually been practicing for so long that it's actually taken me longer to kind of default to thinking, oh, EFAA, we can get out of arbitration with this. I'm a younger attorney. So he's like, it's actually a little bit more second nature for you, because this has just been a bigger part of your practice. So if you're having it, some attorneys purely just, again, if, 20 years of their experience is that arbitration agreements are just, impenetrable, it might not be as, they might not have the reflex basically to just say, oh, I've got the EFAA that I can work with. So flagging it for them and just documenting your experience.
I guess I'll ask you both. Do you have the sense that most attorneys are familiar with the EFAA? Because just to be clear, as we mentioned earlier, you don't need to let employees know that the EFAA exists. So if you're an employee and you're thinking about potentially going to see a lawyer and you look at your contract and you say, wait a second, I've got an arbitration clause, I can't even sue, if you even know what an arbitration clause is. I did not, so I'm not suggesting that a lot of people might. But do you have the sense that most lawyers are aware of this law or using this law, or is this an age demographic?
I would say that it probably depends. I work on a floor actually with a bunch of different employment attorneys. So we all specialize in this area. So we know about it, but somebody that, if you're going to an attorney that maybe has more of a generalized practice, I wouldn't be surprised if they don't. And also, I think another important thing too is, I was talking to just, again, some of my fellow employment attorneys when we were trying to get Nicole Pullen's case out of arbitration. And I mean, really, if you look at the law, it's just written in such a broad way that there's really a lot of fun you can have with it. Honestly, there's a lot of just really good legal arguments you can make with it, just purely based on how it's written. And so even if it's not actually the thing that kind of got me even thinking about making this legal argument for Nicole Pullen is, I think the attorney's name is Paul Bowman, but he did one where it was actually a coworker that had reported seeing his colleague being sexually harassed, and they retaliated against him for even just opposing, viewing or just observing this sexual harassment, and that got out of arbitration through the EFAA. So I think just kind of being a little creative with it, honestly, and not, taking your time looking at it and not just thinking, oh, it has to be a sexual assault or sexual harassment standalone claim. That's not the case, actually. It also works for retaliation. There's a lot you can actually do with it. So it's a great law, honestly.
Thank you. We're so glad about that. And we're going to continue, I hope, to work with David to be able to continue to, look at this every year to see how the cases are changing and morphing and including more protected classes. Another question from LinkedIn, David, a great one. Do you think the EFAA is changing workplace behavior or just litigation strategy? And let me just preempt that by saying that part of our mission in trying to pass this law was to include both of those things, because we always said it's a double whammy. Not only do you get these cases out of arbitration into the court system, but you might also stop the behavior, because now the person who's doing these bad things knows that you have a voice. Your thoughts?
Yeah, no, that is such a terrific question. And I have to think the answer is yes. I think it must be changing workplace behavior because, any employer that has a compliance department that, wants to make sure that it's following the law, but also, is applying common sense, will be aware that if they allow sexual assault or sexual harassment to persist, not only will they face legal liability, but because the case will probably be in the court system, they're going to get a bad name. And, they're going to have a reputational effect as well. So I think, this is just a testament to what great work you guys have done to try to actually, stamp out the underlying wrongdoing.
Where do you think the next legal battles over this statute are to emerge, David?
So in terms of issues that haven't fully sort of come up, one of the issues that my eyes were just open to, I have to credit to another law professor who teaches at the University of Indiana named Deborah Wittes. She's an expert on sexual harassment law, and she has a paper that's coming out that's just about sexual harassment law in general, but also mentions the EFAA. And I think one of her outstanding and creative points, which relates to what Holly was saying about the statute being so broad, is if you have an employee who has suffered, say, maybe one instance of sort of inappropriate touching at work, that probably will not be a sexual harassment claim under federal law, because federal law requires sexual harassment to be severe or pervasive. And there are cases actually saying that one instance or two instances of inappropriate touching is not severe or pervasive. But what Professor Wittes's point is that even though that will not be sexual harassment, that fits squarely within the statute's definition of sexual assault. Sexual assault is extremely broadly defined to mean any instance of inappropriate touching. And if you look at the reported cases so far, very few of them actually involve claims of sexual assault. So my prediction is there are going to be more claims of sexual assault, even if they don't necessarily amount to sort of what you think of when you think of sexual assault, even if there's something like one instance of somebody touching somebody else inappropriately.
Interesting.
Yeah.
Yeah, because I was always told that when it crosses the line to actual physical contact,
Right.
that just ups the ante dramatically.
Yeah.
As opposed to, not that sexual harassment can't also be unbelievably damaging, because it is, to your psyche. but the minute you touch somebody, it puts it into a whole new realm. Julie?
Yeah, and this is kind of a rhetorical question because I don't think we can know, but if this law had not passed, can you imagine what would still be buried right now? I mean, Holly, you would know, right?
Yeah, I mean, this, the case that I'd kind of described earlier where the disability discrimination was the bigger thing for her. I mean, something that has been that case has been, I mean, again, it seems very weird that like these are the kinds of cases that I get excited about, but I am a lawyer, so the cases I get excited about are like the crazy ones. But like, and so, that case, for instance, I mean, because of this element of sexual harassment, it's actually, frankly, it is just really revealing at this particular company all kinds of discrimination, because again, the entire case is coming out. And also, I mean, just frankly, the wave of employees that I've actually, in that particular case, I've never had so many witnesses that have just been more than willing to speak with me, because they just had so many kinds of discrimination going on, and like it's been mind-blowing, honestly, and none of that probably would have happened if we were in arbitration, just because just kind of the way those things play out. So it's not only has it been unbelievable, I mean, and just what I have myself witnessed for sexual harassment and sexual assault, but frankly, as a byproduct, all these other kinds of discrimination, because unfortunately what you see is if you've got somebody that's awful enough to really engage in some egregious sexual harassment, it's probably no surprise that they also engage in other forms of discrimination as well. So it's really uncovered some crazy antics, let me tell you. So
Yeah, I mean, I can totally relate to that, Holly. I mean, we always say as an organization that if a company silences you on these kinds of issues, They probably are also not paying you fairly, not promoting you adequately. I mean, all of this stuff with the explosion of forced arbitration and NDAs has allowed companies to cover up their dirty laundry for years and years. So I'm not surprised that when the floodgates, open a little bit, you start to hear from more people, because as we continue to try and educate more people about these issues, they're realizing that they might have a voice. And that is incredibly, incredibly powerful. I would also just say that, had I almost had to abide by my forced arbitration clause. And arguably, if that would have happened, we wouldn't be having this conversation right now. I would have also gone into secrecy. And the only reason, which you lawyers will love, is because my lawyers were able to come up with an incredibly creative way to sue my alleged perpetrator, Roger Ailes, personally under a human rights law in New York State, because it was incredibly broad. Otherwise, I would have also gone the way of thousands and thousands and thousands of American workers who have never been able to adjudicate their claims in open court. And David, I don't know if you have any thoughts on that, about just this sort of phenomenon of companies being able to get away with silencing their workers.
I think one of the points that you just raised really resonates with me, which is the fact that your attorneys came up with this creative argument to sue under New York, did I get this right, city law?
Mm-hmm.
So
yeah.
One of the things that people listening may not be aware of is the fact that the EFAA incorporates city anti-sexual harassment and sexual assault laws. Many cities, big cities, do have these laws, and they are tremendously progressive. And so they're really powerful weapons. We've seen this in a lot of cases that have been reported, where if you can't bring a claim under federal law, Title VII, or even state law, you often do have a claim under city law. So it's really worth investigating whether or not that's true, because you may discover that an employee who you think can't invoke the EFAA actually can using city law.
It's such a great point. And if you're working in New York City, this human rights law is incredibly broad. And thankfully my lawyers were smart enough to come up with that.
But not just New York, I just want to be clear. I mean,
not just New York.
The country. So if you live elsewhere, you really do investigate the laws in your own city or state, because some of them are quite broad.
Yeah. One question that I got from somebody that I actually know in the chat that I want to bring up, because it doesn't have to do with the EFAA, but it has to do with NDAs, which are the second thing that we fight. And in case people don't know, after we were able to pass the EFAA on March 3rd, 2022, we went back to the same coalition of bipartisan lawmakers to try to get a law on the books about non-disclosure agreements. And so this was called the Speak Out Act. That was signed into law a short 8 months later, on December 8th of 2022. And what that does is it gets rid of pre-dispute NDAs for sexual misconduct that you might have signed on your first day of work, not knowing that you were signing away your rights to have a voice, and that you're allowed to keep your voice all the way up until a dispute arises. So the question that I'm getting is, how does any of this connect to those of us who've had to already sign NDAs? Can we get out of those? And unfortunately, the answer right now, I think, to both lawyers is no. If you've signed them already, right? There's no retroactivity for that, although we continue to work on this. Holly, do you have any response to that?
Oregon, thankfully, we have the Oregon Workplace Fairness Act. And that actually applies to any kind of unlawful discrimination. So frankly, that is just the law that I have the most experience with, because it's a great law, honestly, and it applies again to just so many protected classes, and that is retroactive, I believe, actually. So I'm actually not quite as familiar with the federal version, just because I'm very fortunate to practice in a state that has this fantastic law. But let me tell you, I mean, just to briefly speak to that in a way is actually, for a lot of my clients, is actually a bigger thing for them than even the arbitration. Like, just the thought of being silenced is so offensive to them, understandably so, and just so upsetting that, and especially just in the healing process, not being able to share your experience is just horrific. So it's I mean, just getting out of these ridiculous NDAs is very important.
David, do you have thoughts?
I mean, I agree with absolutely everything that's been said, and just the only thing that I'd really like to highlight relates to what Holly was talking about, which is when it comes to arbitration, unfortunately, because there is this federal statute that makes arbitration agreements really hard to invalidate, state law on arbitration is often not effective for employees. But when it comes to NDAs, state law is much more effective. So if you happen to have a case involving an NDA, look to state law to see if there's a similar statute to the one that Holly described.
We actually break that down state by state on our website, so liftourvoices.org. You can go and see, and there's 3 states, New Jersey, California, and Washington State, that have banned NDAs for toxic workplace issues. We've also introduced legislation similarly in New York and Connecticut. And also we're looking at in Oregon, Holly, and New Mexico as well. So it's really important to know what your state law says with regard to NDAs. I guess I'll just wrap up though by saying that, ironically, Julie and I are still silenced.
Right.
You know, and people are always surprised by that, but Julie and I do not own our own voices with regard to what happened to us at Fox News, because we signed unbelievably stringent NDAs when our cases were resolved, not having any idea that we would end up being part of starting a movement and eventually be part of changing laws that would make these, you know, not in effect anymore. So the irony is we work on behalf of millions of other people to own their own voices, because we know how painful that is to not own your own voice. And yet we will maybe never own our own personal stories of what happened. I mean, we know what happened in our hearts, but to be able to broadcast that. Movies and miniseries have been made about our stories, and we can't comment on them or participate in them. So it is this, you know, horrible, eerie, mentally health-ridden place to find yourself in. And we know it's not just us. It's millions of other people who have also been silenced. And that's why we continue our work. Julie, I'll let you wrap up from there.
Well, I just want to thank everybody for being on this, certainly to David and Holly, but also to all the people who joined us today. There's so many of you all across the board, and really deeply grateful to all of you for your wonderful questions and for asking them, because this is a complicated issue. This is not something that is intuitive to people. Most people, when they start a job, have no clue, as I did not, what you're signing. And even if you know what you're signing, you're not really sure how it applies to you. You don't just need a law degree. You need to be like Holly and be an employment lawyer and really be in the weeds on this to understand it. And that's something that is daunting, I think, to a lot of people. But understand that help is here. It is on the way. We are working our way through not just getting rid of this for sexual harassment and assault, but also for every protected class that we can. Whether we get it done this year, next year, or in the coming years, we will get it done. So thank you to all of you for joining us and for joining our mission and for joining our fight. And we look forward to seeing you at our next webinar in the next several months. Thanks, everybody.
Thank you.
Thank you.
Thank you.